Hello, my name is Richard Heenan, and this is my Week 4.1 graded assignment case study presentation for EDU 503. This case study will examine the case of Dennis J. O'Connell High School versus the Virginia High School League from 1978, which is centered around constitutional law. The facts from this case, as well as the arguments from both sides, the court findings, and the implications of the case on athletics and activities administrators, will be reported based on information found in the Pittman, Spangler, and Young text, Case Studies in Sports Law. Founded in 1913, the Virginia High School League is an unincorporated association that, with one exception, includes all of Virginia's public high schools. Originally, the league included both public and private schools as members until 1925, when their constitution was amended to include only public schools as members. The league operates under the sponsorship of the School of Continuing Education of the University of Virginia and is maintained by funds provided in part by University of Virginia and in part by gate receipts from league-sponsored tournaments. The league oversees all aspects of the athletic, literary, and debating contests among its member schools, and the league invites private schools to participate in certain tournaments as a distinct class. The league events that private schools have been invited to participate in include tennis, debating, and speaking, but they have been excluded to league-sponsored tournaments of major sports such as football, basketball, and baseball. In 1977, the Dennis J. O'Connell High School applied for admission into the northern region of the league, but since they were a private Catholic school, they were denied membership because of the league's constitution, which does not allow private school membership. Due to the denial of the application of membership for O'Connell, they filed suit against the league. We will now examine the arguments for both sides of this case in the district court, as well as the decision of the district court. O'Connell brought suit in accordance with 42 U.S.C. section 1983 and its jurisdictional counterpart 28 U.S.C. section 1343(3), and they alleged that the league's refusal to grant their high school membership on the sole basis that they were a private school was an arbitrary classification in violation of the Equal Protection Clause of the 14th Amendment. In their complaint, O'Connell further charged that because they were excluded from the league, those students who attended their school and chose private education were being denied the right to compete on a tournament-level basis in the major sports that the league had excluded in tournament play. This exclusion then placed those students in a less favorable competitive position than their public school counterparts to receive athletic scholarships, professional bonuses, and other benefits that accrued to gifted athletes. In the district court hearing, the league presented three basic arguments for allowing the exclusion of private schools in their association. The first of their arguments was that because O'Connell had not been deprived of any federally protected right, there was no federal question presented so as to support federal jurisdiction alleged to be founded on 28 U.S.C. section 1343. The second argument was that limiting membership to public schools only was rationally related to their interest in enforcing eligibility rules surrounding the subject of transfer students. The final argument of the league was that admitting a parochial school such as O'Connell would be a violation of the Establishment Clause of the First Amendment. Upon hearing both arguments, the district court provided the following findings. The question whether participation in the league's athletic program can be characterized as a right is not determinative of the constitutional validity of the league's classification. There is nothing in the record to support the asserted basis from league membership. The league's activities neither advance or inhibit religion, and any financial benefits indirectly supplied to O'Connell in the form of surplus league proceeds from league-sponsored championship games would not constitute excessive governmental entanglement with religion so as to violate the First Amendment. Because the league had presented no rational basis for the exclusion of O'Connell in violation of the 14th Amendment, and the inclusion of O'Connell would not be in violation of the First Amendment because it would not constitute excessive governmental entanglement in religion, the district court enjoined the league from denying O'Connell membership. The league then appealed the decision of the district court. After receiving the district court's decision, the league appealed, contending that the district court erred in holding that jurisdiction exists under 28 U.S.C. section 1343. They also contended that the district court erred in holding that there is no rational basis for provision of the league's constitution limiting membership to public schools. The appellate court ruled that the district court did properly take jurisdiction of the claim pursuant in 28 U.S.C. section 1343, but they also agreed that the district court erred in holding that there is no rational basis for provision of the league's constitution limiting membership to public schools. The Court of Appeals found that the league may constitutionally exclude private schools from league membership, but did not address league arguments concerning burden of proof or the league's contention that the admission of private sectarian school would violate the Establishment Clause of the First Amendment. Thus, the judgment of the district court was reversed. Possible implications that may come from the ruling in this case would be athletics and activities administrators needing to be well versed in constitutional law, being knowledgeable on constitutional law and what sort of implications can be put on the acts of exclusion to individuals or teams in tournaments or other events that they coordinate to be hosted in their district's facilities. This type of knowledge would also be readily useful in cases where spectators feel their constitutional rights have somehow been infringed upon by the athletics activities program of a district. This concludes my Week 4.1 graded assignment case study presentation. Thank you.